Under Minnesota law, a person injured in a car crash has two potential claims. Now, the first claim is under the contract of insurance that covers you. This may be your own car insurance policy, the policy covering the vehicle you are occupying, or a resident family member's policy, and this is referred to as the NoFault Claim. Under this claim, fault is not an issue. No matter who caused the collision, you are still entitled to no-fault benefits, which allow you to collect at least $20,000 in medical payments, including mileage to and from your doctor. Every Minnesota auto policy also provides at least an additional $20,000 for wage loss, which pays you 85% of your lost income with a maximum of $500 per week. And you may also be entitled to replacement services. Now, these are benefits meant to compensate you for activities around your home such as cleaning, preparing food, or doing laundry, which you cannot do because of your injuries. If the insurance carrier refuses to pay no-fault benefits, you have a right to arbitration. This is an informal hearing process in which an arbitrator decides whether you should be paid for your bills or wage loss. Now, determining which is the proper insurance company to pay your medical bills and wage loss under the No-Fault Act can be very complicated. It is always best to consult an experienced lawyer, such as lawyers at Schwebel, Goetz, and Sieben, if you have questions as to who should be paying medical bills and wage loss from a car crash. Now, under the second part of Minnesota law, you may have a claim against the other driver for your pain, disability, and any out-of-pocket costs not covered by the No-Fault Act. In order to pursue a liability claim, you have to prove two things. First, you must prove another driver was at fault in causing the crash. And second, you must prove that you have an injury from the crash that meets what are called no-fault thresholds. Under Minnesota law, there are 5 no-fault thresholds. 1, if you incur more than $4,000 in medical bills. 2, if you have 60 days or more disability. 3, if you have a permanent disfiguring scar. 4, if your doctors deem you have a permanent injury. Or 5, if the crash results in the death of a family member. You only need to meet one of these thresholds. If you do, you are entitled to compensation for pain, disability, emotional distress, and your out-of-pocket expenses not covered by your no-fault insurance coverage. Proving entitlement to a personal injury recovery from a car crash can be complicated. Always consult an experienced personal injury lawyer like the lawyers at Schwebel, Goetz, and Sieben if you are injured in an accident to be sure your rights are being fully protected.